morning.
Good morning. Bear with me just a minute. I'm going to call the case. Gentlemen, I believe you were in front of me before. Let me check something here. Let me call the case, gentlemen, and then we'll get going. This is the time set for the matter of Garrett W. Archer, petitioner, and Terry Fisher, respondent. This is Clackamas County case number 25PO09587. Present in the courtroom is Mr. Archer, representing himself. Also present in the courtroom is Mr. Fisher, representing himself. If you both would please raise your right hands and be sworn in.
Under penalty of perjury, do you swear or affirm the testimony you're about to give in the matter now pending will be the truth, the whole truth, and nothing but the truth?
I do.
If you could state your full name and spell your last name for the record.
Garrett Archer, A-R-C-H-E-R.
Sir?
Terry Fisher, F-I-S-H-E-R.
Thank you.
Okay, please be seated. Okay, Mr. Archer, I believe you were here in front of me before, correct?
Yes.
Okay. And I believe it was your, was it your partner that was here as well at that time?
She was here previously.
Right. And we heard the evidence from her hearing, correct? And we made a ruling. I made a ruling at that time, correct?
Indeed.
Okay. So, in some ways, I'm going to start with you. Because I've heard some of these facts already, I'd ask you to do more of a summary approach. Mr. Fisher, same way with you. A summary approach on some of the, what I need to know is what's different from last time versus this time, okay? And some of the best recollections of what's been happening at the property.
Okay.
Because
So
it's all occurring at the property, right?
it is. I wasn't actually here for Ashley's hearing.
Okay.
So I'm not exactly.
Oh, you weren't. I remember that you were.
I couldn't make it to that, but I did appear ex parte remotely.
Okay.
For my hearing. So.
Right.
But I don't know if I could speak to the changes.
Well, I've got some history on the case, and so that's why I'm kind of thinking rather than take your time.
Okay.
But I don't need all the minutia that we had from way past.
Of course.
That's why I'm saying.
I was going to say that my disabilities that are kind of central to this case make it difficult to get counsel and have made the situation very bad. So I was hoping that the court would consider that when weighing the decision today. And I also might be a little procedurally naive, kind of moving through things. I wasn't sure if it might be worth asking if the court wanted to hear from our case later in the hearing today or not.
So I can address a couple things right off the top of the bat. Procedurally, in these cases where parties are representing themselves, I don't hold the procedure very tightly. Okay. My style is I want to hear the narrative type of thing. I will apply the rules of evidence. Sometimes the parties say that I object to this, and we can kind of feel out why. What's the objection? Sometimes I add an objection myself, just to police the record, just to keep the right things in and the wrong things out. The part of having another hearing date, that's called a set-over. And I'm thinking I'd rather hear the case today and get it resolved, knowing something already about it.
I just meant to suggest that we could go later in the present hearing if it was more expedient for the court than to have me kind of.
Well, actually, the next matter, you're the second of three at the 10:30 docket.
Oh.
Okay, so we got some time. The next matter, I'm going to be placing my hands into it. So that's the one that's going to be occupying most of my time between now and basically early afternoon.
Okay, awesome.
So
I have tried to prepare fairly extensively too. I just, the disabilities kind of inevitably lead to a bit of a convoluted case when I try to give it to even a lawyer. That's where I end up. So
I understand that part. That's why I like using narrative styles
Mm-hmm.
versus the polished version that
indeed,
an attorney would give me. It's like,
can-
that's why I like to have kind of an interactive
I
with
can
you.
try
as
to
you're,
do that.
yeah, so when you're talking, if there's something like I miss, I can just ask, okay,
Mm-hmm.
back up a little bit, give me the detail there, type of thing.
And so I had a couple procedural things that I thought would be worth asking about.
We'll definitely bring them up, inquire about them, okay, and I'll give you the best
Is
answer I can give you.
that's to be done before the narrative portion?
Yes, procedures always, even with lawyers, they'll always ask the judge to weigh in on the procedural matters before they have what we call the substantive part of the case.
Excellent.
Okay.
Just the two procedural things that I was interested in were a motion to have the court recognize this as a complex case, kind of in line with a motion I had filed in a landlord-tenant trial, as you know, that's co-occurring with this. I had filed a motion to consolidate, which wasn't the path forward, but I was curious about making it a complex case because of issues with discovery. And I mean, thus far with the protective order, there's been, no compliance with the local rule 6.083 for the exchange of documents and the stipulation to that beforehand. And I wasn't sure how much that might.
Couple things I can address. Okay. Consolidation. Consolidation is a means by which we put an order of consolidation. Bear with me, Mr. Fisher.
Yeah, I'm listening.
Okay.
I'm trying to learn also.
Oh, no, and part of it, I love this part of the job where I can elevate people's knowledge of how we work and why we work, and it all makes sense if you get the explanation of why we do things this way and what it means. So you think about consolidation, we blend the two cases and we hear it all together in one big picture. That's not how it works. Consolidation in the court system is we put an order in each of the cases, and the cases are identified by case number. Okay? So if you notice, when I read out called the case, I said PO. That stands for protective order. Okay? We have SCs, small claims, DV, domestic violences, all these type of DR, domestic relations. Okay. So when you get the same parties in two different cases that have two different case numbers, what the order of consolidation does is it cross-references everything. It does not bring the matters together to be heard at once. It gives us the way of tracking what happens in one case may flow over and be relevant in a second case. We don't hear them simultaneously.
Like as far as the evidence is concerned, right?
Well, that's a different. Okay, so the order to consolidate is that in the records, the two together.
Right, yes.
Now, you raise a very good point, and this is something that's important to everybody. When you have a hearing, both parties are sworn in, so they're under oath. There's also an element of what's called cross-examination. So if someone presents documents, there's cross-examination. It is then admitted if it's admitted into the record, what's admitted in the record of one case can be recognized in another case. You understand? Because we've established its trustworthiness. Under oath, subject to cross-examination.
Is that only true if it's a certified copy of the transcript?
Well, that's a rule of evidence, and it depends upon what the transcript's about. Okay, it doesn't necessarily mean to be a certified copy. Certified copies alone don't rise to the level of what we call admissibility under the rules of evidence. There's some exceptions to that. Now, if we have the person that actually created the transcript testify, then it doesn't matter if it's certified. You have the author of that document present. If you think about evidence overall, what we're looking for under the rules of evidence is that first person awareness. I saw, I wrote. So like people say, I want to introduce a doctor's report. Well, that's hearsay. That's a statement made outside of court. If you have the doctor testify, then the doctor says, I wrote that thing. Police report's the same thing. I got a police report. Do you have the officer that wrote the report? Because otherwise it's hearsay. So some of the things that are created by people that think, well, it's official, it is admissible.
Right.
It's not, because you really want to get the author, the person that did it. On the other hand, you can say, let's say you were in a situation, you're in a fight with your spouse, there's altercation, the police are called, the police arrest her and haul her away in handcuffs. You witness that, you can talk about it. And if you said, oh, a friend told me that she got hauled off with handcuffs, inadmissible. The friend's not here. You just heard it through the friend. You didn't have that first person experience. So keep that in mind in terms of any time you put in sort of any evidence. This is go for you too, Mr. Fisher. He said, I took the photo. I saw where the car was parked. I. Gives me the basis that, okay, you're the person that testifies what you know firsthand.
Indeed.
Okay. As for the complex case designation, just because there's two cases doesn't make it complex.
Indeed.
Complex is when there is lengthy evidentiary type of thing. We're talking multiple day trials. I'm an engineer before I was an attorney. And construction defect cases, where you get contractors and all that type of stuff, that's a complex case. In terms of you get the designers in here, you get the architects in here, you get the several contractors, you get the subcontractors, and you go on for several days with mountains of documents. That's the idea of complex case designation.
Fair enough. Yeah, I do understand that. I think the complexity on my initial approach to that was mostly due with the accelerated pace of the Fed trial and the basis that I'm trying to get discovery and exchange of the documents in both cases.
Right. And my suspicion is that what evidence you need in the Fed, the forcible entry detainer case, probably is what we're going to call relevant to what's here. Because what we're looking at here is personal actions type of thing, not the contract relationship. And that's what an FAD case. It's a contract. It's a rental agreement and all the terms that go into that, spoken, unspoken, the application of that type of law type of thing. What we do here in these cases that I'm hearing is we look at people's actions and how they make me feel. And do they rise to the level of being threatening? Is it reasonable to consider to be threatening? Some of the history, because that explains the context of actions and words that are said. So that's what I come back to. Is I'm looking to, and if you think about that, what I have in my courtroom is a lot of people's personal stories. And I don't know if you remember when you were online, but that's what I asked for. So I asked for that narrative of the personal story because that's really the evidence,
of course,
that carries the day or doesn't carry the day.
Indeed. Well, and that narrative may go a bit to explain kind of my thinking of the previous things as well.
Totally fine. Totally fine.
The reliance on the evidence, I guess, is born out of, not really having much personal experience with Mr. Fisher. That contract, was executed 17 days before we filed an accommodation notice that led to an immediate termination.
You moved in like July, if my memory is correct on that.
I believe
summer?
It's June 29.
Right, almost
Yes,
July. Yeah, I remember that. And I remember the setting. I do remember the pictures that we introduced last time, which was the building and the center door and all the garage doors to either side. You testified about your business with a lot of work of equipment in there that you needed access to. I mean, there was photos of where things were parked. There was photos of the front door.
But the fundamentally, especially at the current state of the property, which is evidenced by the termination notice, comes with a picture of the front of the door, and it's
Right. The notice was
but that was the time when communication cut off completely. A reason for which was not given for a very long time, and then there was like an escalation quite rapidly, absent again of the known reason for why this was happening.
You're talking about escalation like the words, right, and the communications, not everything?
Well, the lack of communication. I mean, as far as my understanding was, we were talking and everything was all good.
And there was the position of the cars, was it not? And the cleanup of the items?
No. No.
Didn't he actually testify about the position of his truck in front of her car, that she couldn't get out?
That all happened after. I do have photos of the timeline, but the vehicle thing occurred after the first termination notice, which was only 6 days after my ADA request.
Okay.
And again, no communication in between that, and there was never really any official communication after that. So, for us, it was like presumed to be retaliation, and then then they got a lawyer who, of course, I feel was kind of getting back to our demands and complaints with, saying, you guys are also messing this up, and kind of leading.
Back to the property, that in terms of you're leasing the property.
Absolutely, yeah.
Okay.
Yeah, it was very focused on that, but
Mm-hmm.
all the while, we're attempting to communicate now with his attorney,
Mm-hmm.
and to get the kind of escalating harassment.
Mm-hmm.
He was like, I don't know how much is in the petition. I had tried previously to get this protection order, but I mean it was a very clear pattern. The Ashley did say they talked about that's hearsay. I should call it on myself.
Well, no, so if you're reciting what you recall, that Ashley said under oath, remember, my memory's still here. I'm still tracking that case.
Fair enough. Oh yeah, that's awesome.
So you can say Ashley said in the previous court.
But yes, to the cameras. The cameras were egregious. And one camera was put up. It was like a couple days after, we were no longer talking. And that's a camera facing directly our only point of ingress and egress.
Yeah, I remember seeing the picture. It's that one door in the front of the building. Right.
Yeah, and it I think is in excess of the typical camera for security purposes, pointing to do that kind of a job. And even after that, another camera went up, and this one follows you as you walk around. And the shooting incidents, primarily that are outlined in the petition, were incredibly upsetting.
And he was out in the field, were you not, Mr. Fisher?
I was on my front porch
Okay.
shooting at a squirrel the opposite direction. He was.
Well, what I was saying, we were distinguishing it like you were not in his presence, you weren't like
No.
threatening with a gun, you were
No.
on the property, and you were just
I was
charging a fire.
on the neighboring property.
Okay, or neighbor property, you were just charging a firearm.
Yes.
That's okay. Yes, please continue, Mr. Archer.
Yeah, so it's just my experience of that it was at a time in which I was walking closer to, I guess, his house than usual. It was highly suspicious that was a random time that he chose to shoot squirrels. And also my own experience of having been there at that point for I thought it was 6 weeks, but I would have taken note of firearm fire while people do shoot at times. It is
and especially in a rural setting like yours, right?
But yes, it was out of the ordinary, and it scared me, and the police were involved.
I do remember that. Yeah,
and
we actually talked
the
about
second time it occurred.
That's about moving the car and having time to get out of there, right?
The second time the shooting thing occurred was at 10:30 at night, and the police officer in that case, seemed, in my opinion, to agree with me on that. It seemed a lot like menacing, if not, obviously the second time I'm like, okay, well, I'm not dead, so maybe he's not trying to hit me, but it's just like a pattern of egregiousness, and that with the unknown reason leading us to get evicted. I got my stuff out of my storage unit because we're intending to, go somewhere else, and I put it in such a way that he could no longer watch me and potentially shoot at me. The false imprisonment thing that happened. False imprisonment is what we thought it was. It was not characterized as such by the Clackamas County Sheriff. But I have
not being able to move the car.
Not being able to move the car. Yeah, no, it was. I'm confident it was false imprisonment, and I do have evidence of the authenticated 911 CAD log. And 20 minutes before he arrived, the initial call to 911 came in from him or from his party, and it's very odd.
So Mr. Fisher called 911
before he got there.
Belief?
No, yeah, it's shown quite clearly, and it's weird. I would like to submit that. I don't know if there's a.
You think the timing makes it weird?
And it says very clearly on the report that he was not at my house, but he was calling 911 on me, and his declaration from Charlie Russell presented in the last hearing. I don't know if I can reference that, but that states he was there to witness because of prior incidents with a gun and, thinking that we would start something. And so for me, that's a pretty interesting thing to call 911. I would hate to say what exactly it says because it's.
What are you talking about? So the call to 911, the police show up. You believe that Mr. Fisher placed the call to 911.
He called. We didn't know that at the time.
No. But you're reciting the history.
Yes,
You
and
didn't call
at the
911,
time
he did.
The dispatcher at one point called Ashley by his wife's name, and we thought that was very odd. But that was only understood once we actually got the address report that told us where to look precisely for the specific report that we needed. They called and said I was using some sort of a torture device that they can't see, but it hurts them and it's criminal. And the way that the police officers treated us eventually, there was confusion, I think, about what was happening. And when I told them that I thought it was egregious and false imprisonment, the police officer motioned to my, admittedly not great looking assembly of possessions, but he said, "You mean this?" and pointed to my possessions, which, I
remember the photos. Yeah.
So I mean, and I understand, but it made a lot more sense when you see that call came in beforehand,
Right.
and she's the first caller, and we're calling 911. 20 minutes later was the first time when she realized that she wasn't going to be able to leave. And the majority of the blocking of the egress there are the vehicles that he moved into those spots. I asked his attorney repeatedly for a parking policy. I've requested for reasonable accommodation for clear communication because of my 2E ADHD and clear rules. And that's kind of the thing is like the rigidity of a structure for me to have and I can adhere to. And indeed, until there was lots of conflict, there was no question as to the outdoor storage of things. And so, that narrative leaves me a little scattered. I don't know exactly where I'm at.
No, remember, I've got the history in the case.
For sure.
Remember dates.
Indeed.
Remember photos and stuff like that.
But always wanted to negotiate. Always wanted to figure stuff out. At this point, the discovery thing is quite scary to me. The second that I was looking to get that done, having worked with his attorney a lot, all of a sudden there is no attorney, and even just the local court rule that I had mentioned with the
exchange of discovery. Like
if we can't talk at all in good faith with our relationship, at least during this, I think we should try to. I don't want to be prejudiced by not having access to something, because this is how I've gotten to know everything is.
Unfortunately, coming to court and hearing about it and having the people under oath testify and talk about
Indeed.
what their positions are.
Yeah, absolutely.
And what they've done and what they haven't done. Okay. Anything else that you want to tell me just about the history?
I potentially. I mean, I do have exhibits.
What are your exhibits?
I did have a bit of a structure that I was going to try to
because I know
figure
a lot of
out.
what we're talking about lack of communication between the two of you and how you felt about actions he's taken, shooting the gun.
I felt like if we had a conversation, it would have been figured out in half a second, and I said as much, and that's when the altercation happened with him running up on me and puffing up into my face. When I asked why is this happening, I still don't have a clear answer as to why.
Right, what his motive was and what he was thinking during that time.
But it's literally an unknown. Like, of course, there's fear. I got nothing out of him. Just,
failure to communicate, right?
Yeah.
What is your evidence? What do you have there that's evidence that's related to what the dynamics are between the two of you?
So, and again, I think that's where I do struggle because it's hard for me to differentiate a lot between great evidence and decent evidence.
But I'm getting, okay.
There are a couple of things that I was positive.
Okay, what do you have in mind? I mean, let's go through bit by bit on what you have in mind in terms of, we're talking about documents now when we talk about evidence.
Can I give him, because I have to give him copies, right?
Okay, you're right. So is that a set of copies for him and you've got your own set of copies?
Yes, I believe so.
Okay, so yes, you can hand to Mr. Fisher his copies. Okay, now just bit by bit, tell me what you got, and we'll talk about whether it's relevant.
That 911 log was oh my gosh.
Okay, so the 911 log is to tell me that he called 911 before you did, right?
Yes, and I could read what was said, if you would like.
Okay, so how do you know it's from Mr. Fisher that called 911? Was it a telephone number?
It was from his house.
Was it an address? What's the identified information on the log?
Let's see.
I do not have a house phone.
Then, okay, well, I'll dive into this, Mr. Fisher, and why he thinks it's you called. What makes you think, Mr. Archer? What makes you think that call, 20 minutes before your call, came from Mr. Fisher?
Yeah. So when you request the records, it becomes clear because our calls end up not being handled in the format of being the entirety of a call. They get appended to the original quote unquote call. So
okay, you got a log. Why do you believe one of those calls is from Mr. Fisher? I mean, is there a recognizable telephone number?
It's the address 44871.
So it's a report of the address, which is your address, and you've seen.
911 reported it.
Okay, 911 reports an address, which is your address.
No,
okay?
He has a different address.
But you know the address.
Yes.
You recognize the address. And that was done time-wise, 20 minutes before your call, correct?
Yes.
Okay, so that's what you've identified. So he called first.
Mm-hmm.
So that log doesn't need to come into evidence. It's basically substantiates your belief that he called 911 first.
Yeah, and I thought it was just in the one, but I might have to submit all of them, unfortunately, because every call we made has it created a specific log.
Okay. Okay.
I suppose.
And remember, you can testify about what you did for your telephone call. That's your first-person experience. You called.
Well, if I need to, it just says in here as well that I texted 911. I felt like there was something sinister happening, and I think his declaration from his friend who showed up because I had previously had a gun. That seems like a weird reason to show up to a loading of a trailer. And there was a claim that we had been notified ahead of time. That did not happen. And why not just let her out before 2 hours passed? But yes,
So what's your next bit of evidence?
I have communications between the respondent and myself.
Okay. Are they text messages, screenshots? What are they?
They are in the form of, well, there's termination notice, but primarily emails with his counsel that is no longer with him.
And okay, so since you created these emails, you can testify.
Yes.
What do those emails say?
Yeah. Okay. So I see the narrative thing being helpful now. They say that we've had problems since the beginning that have been not addressed.
And this is largely the landlord-tenant issues. Correct?
Absolutely.
Okay.
But again, I guess maybe because of the way I think or because I have not actually seen the reason behind the overtly hostile behavior. Right. To me, it seems very much related. I mean, he wants us to not live there.
Yeah, evidence of his thinking. Right, what you're seeing there.
Yes. So, and indeed it is landlord-tenant issues, but as far as the statutory requirements for the protection order, all sorts of things which are in my primary defense for the Fed case of retaliation is, the harassment behavior. I think a lot of it is reduction of essential services, even.
Which would be a landlord-tenant question, clearly, because that's what the contract is that you're to provide.
Indeed. But I think that applies to the elderly and disabled protection as well in a somewhat unique way, especially if it's willful. And my most strong assertion of this whole thing is that good faith has not existed at all. And that's left me in a hard position to navigate from a already hard position.
And have you moved out now?
No, we're still in there. The Fed case is coming up next. It's on the 28th.
Okay.
Mm-hmm.
Okay, about
So,
12 days out. Okay.
Yep, we're hoping to figure it out then, but yeah, there's no way to negotiate. That's why I had asked for that complex case, because I have no idea how to get any shred of discovery or anything that I need short of a motion to compel or something. And I would think that would apply in both things.
It would, well, the idea of compelling discovery, when it's these type of cases, usually, very rarely you have any need to compel people because you're getting this, what it's like now. You've got really almost all, you already possess all what I need to know.
Mm-hmm.
Motions to compel usually are about financial documents. So those are really common in divorce cases. We do a lot of motions to compel in divorce cases to get more access to accounts and things like that.
I find that I might not appear as credible as I would want to, maybe.
No,
And so it's masking a thing with this.
I think with you, you're not as polished as you'd like.
Yes, certainly.
Yeah.
Yes.
No, credibility is you're doing fine on the credibility.
And so I guess just all of the individual egregious things. Shutting off the electricity was egregious. That happened.
Mm-hmm.
His maintenance worker told me that it was caused by something specific.
And how long was the electricity off?
The electricity was off for the better part of a day.
Mm-hmm.
I wasn't told when it was turned back on because it was turned back on without anyone accessing the electricity. But before it was turned back on, the landlord's agent or the landlord disconnected the emergency extension cord that I was using to get power from the building nearby that had power. That seemed outrageous because whatever reason the electricity went out in the first place, then unplugging of the cord, that didn't make sense. But the hot water didn't work for 6 days. The outdoor hose hasn't worked since the 21st of July. The AC stops working constantly. There were habitability issues. That's getting a bit further into the definite landlord-tenant area, but landlord duties do not exist in this contract, apparently. There's no one I can talk to about anything. I've never had a response to an accommodation request, let alone a participatory process that I thought existed to let people participate. And also, at the end of the day, I think this order should stand, at least, until we can figure out the other case, or because I need to prepare for that case and return to the old status quo of, stomping on the roof of our house and constructing whatever he was constructing on the roof of our house, and being surrounded on all sides. There's actions and, constantly filming me. The camera is ridiculous. His lawyer denied for months that the camera even existed, denied that the water was turned off. He kept saying, it is confirmed that the water is not turned off. And then, eventually he does concede a couple of things, but the camera, he never concedes. He doesn't work for the lawyer he had anymore. But yes, it is just so much. I would not use the egregious word super lightly. I mean, it's almost.
That's your perspective. Your perspective, this is egregious.
Indeed.
The summation of all the actions or inactions on his part is egregious.
Yeah, and easily solved. I don't have any idea how I could get the things I need to not be prejudiced in the setting if we can't even have a conversation, as I tried to serve him papers after the last hearing. And in the courtroom, he yelled, "Get away from me." And I got embarrassed and left.
So I'm going to ask Mr. Fisher to
Sure,
respond to
of
some
course.
of the things. Mr. Fisher, just again, the narrative, you've heard a lot. You can address what you'd like on that one. I want to hear just your response to what.
Well, there's so many things that he said that are,
But a lot of it's repetitive, and we've heard a lot of it before with the previous case, and so I'm not too sure how much more you're going to add that I remember hearing you say.
okay.
And I know
I'll
that
try to remember them, and they'll probably pop
and
up
a lot,
in
and a lot of
different
this is
orders.
landlord-tenant related stuff. That does the petitioners admitted. So.
Yeah. Well, first off, I'd like to say he sent an email to my lawyer at the time saying, zero contact provision. Your client, Mr. Terry Fisher, is to have zero direct contact with us. This includes verbal communication, written notes, gestures, and any form of physical approach. All necessary communications from the landlord to the tenants must be routed exclusively through your office.
And what's the date on that?
Oh,
No date.
I don't, let me look and see if it's on the top of the front page.
You know, there may be something up at the caption level.
August 5th.
Oh, okay. Okay.
So it's been quite a while back.
Mhm.
So if he wants to know why I don't say anything, it's
But
for
you-
his
you-
request.
Okay.
And then the gun situation, this is I've heard about the second shooting only 2 days ago. I know nothing about that.
And was that, okay, you don't know anything about it. It's the first time you were at the neighbor's property, right?
At my I own two 20-acre
Right.
parcels side by side, and where my house is in the second.
Right. Okay.
And so I shot at a squirrel off my front porch in the morning. And the only reason I was shooting squirrels is because he said that there was rats in his house, and I told him, no, there's squirrels. So I had to hire a pest control company to come up, and they agreed, no, it's not rats, it's squirrels. And so it's not that far. It's only 800 feet between the two, and there's a lot of squirrels down
I
at my
remember
house.
the aerial shots that you provided last time.
What's that?
I remember the aerial shots that you provided last time.
Yes. And so I was trying to get a handle on the squirrels down there so they don't migrate back up to the shop, and I have to go through this whole process again. And also the thing about the electricity. He says that nobody works on it, or nobody does anything for him. He contacted my maintenance man there and said that his electricity was out. And so his name is Ronnie Lee. Ronnie called me, and I says, well, can you please go up there and check it?
So did you give Ronnie's information to Mr. Archer at one time so he knew to contact about the maintenance?
He's known all along that Ronnie is the man that does things
So he
there.
knew, he had foreknowledge to contact Ronnie on that issue of the electricity.
Oh, yes. Before he rented from us, Ronnie was prepping the apartment, painting and cleaning and doing stuff when he was there. So he knew Ronnie from the very get-go.
Got it. Okay, good. Okay.
And so anyways, ended up, Ronnie went up there, and he couldn't figure out what was wrong. And so the next day, he says, it's too late at the evening, I'm not going to do it right now. He says, I can't do nothing about it. So he says, I will come back tomorrow. And so Ronnie got a hold of him the next day. He went in there, and the main breaker was shut off. So it wasn't flipped. You know, when they short it out, they only go halfway back. It was shut completely off. And Garrett told Ronnie, this hearsay, I guess, that you caused your own problems.
Okay.
And the AC breaker, that day or the next day, he's complained that his AC wasn't working. And Ronnie went back up there. The AC breaker was shut off. And then I think prior to that, it was on a Sunday, he got a hold of the sheriff's department and said that I had shut his hot water off. This, mind you, is when I've got the restraining order on me and I can't even go on the property and nobody's been up there. So I can't do any of this stuff. And I have family around me the whole time. I wasn't even there. And so Ronnie goes up, or I sent.
Ronnie up there for the sun.
Well, first off, I sent my Marie up there I says, can you go up there, open up the shop door, turn on the hot water, and see if it's warm or hot or anything. She went up there and she says it's lightly warm, but she didn't let it run for a long time, you know. So then my sister was with her, and I says, on the phone, I says, can you go upstairs and on top of the on top of the roof of the apartment and go up there and see if the hot water is leaking or anything like that, the heater. And so they walked up there, and of course it sounds like they're stomping around, I guess, because there's only this much ceiling, you know. So they walked up there and checked, and there was nothing leaking or anything like that. So then they came back, and I sent Ronnie up there the next day to see if, I says, I want you to go up there on the hot water heater, take the inspection cover off, test it with a meter, and see if there's any power to it. He tested it, there's no power. He went downstairs, went into the apartment where the only breaker box in this building is, and he had shut the breaker off. So he was complaining that I was doing all this stuff when he was causing it himself. So, and to cover, there was a few other things.
Yeah, don't go to the stuff that we talked about before in terms of the parking of the cars and.
No, I'm not worried about that.
I've heard all that from the past.
Yeah.
I haven't heard any of that.
Okay. So I think you've given enough for what he was talking about in terms of some of the, what he is saying is that you created an environment that was bad for him.
I understand what he's saying, but I wasn't even there. I didn't.
I've heard your version of what factors he's claiming made it a bad environment. Yes, Mr. Archer.
Sorry. Is it time to ask questions?
Well, I've heard from Mr. Fisher. Do you have questions for Mr. Fisher?
I do after that, yes.
So I'm pretty close to ruling on what we're going to be doing here. So what questions do you have for Mr. Fisher?
I was just curious about the timing of the electrical that was mentioned. You talked about a water heater thing that wasn't mentioned, but to address that, I was trying to fix the AC, and Ronnie was there when we came to understand that the way that it was configured, which by the way isn't labeled, we thought that was the AC, and so we were trying to fix the AC by like turning it off on that part.
Take the part
So that's how it was explained to us. But yeah, it was nice that the water heater was fixed, but Ronnie did not come back in the second day. The text messages prove that, and it still doesn't explain why the cord was unplugged to the emergency power. And yes, other than that, you know, the idea that you could be talked to through your lawyer who doesn't exist, isn't employed by you, is weird. And I've even like talked to Ronnie Lee and said multiple times, like, let's figure something out. I guess.
So I've heard enough. I've got plenty of history now with the two hearings. Okay, so we do have an overlay here of the issues with landlord-tenant, and above it we have an allegation of abuse. Abuse has to reach certain levels of being significant, well-founded, credible, reasonable, not subjective but objective. While there has been difficulties in communications and animosity possibly between the two of you, it doesn't rise to the level of finding that there is abuse. And so I am going to dismiss the elder abuse order.
Can I ask a question?
Procedure or what?
About the whole thing, I guess? I mean, it's a simple question.
I'll see if I can answer it. I may not be able to answer it.
Okay, I mean, if you can't, you can't.
Ask the
I
question.
understand. Since he's tried multiple times to get restraining orders against me, he did this one the day that the other one was let go.
I know, he got it the day that they were here for the first one, right?
Is this going to continue on? I mean, is there any way to, I mean, because I've been held out of my shop for 42 days now, and customers are mad at me because I can't work on their vehicles, and
So
I'm just trying to protect myself.
At this point, we cannot bar the door to the courthouse.
I understand.
So what we hope for is, and I won't get into it, is that there'll be a higher bar before the next one's given out. Higher standard, higher bar.
Okay.
That's only I can assure you.
Thank you very much. Thank you, Your Honor.
Deputy, I'm going to ask that you let Mr. Fisher go with his wife, and then ask Mr. Archer to stay back a little bit for like 5-10 minutes, please. If you'd stagger that release. You're welcome, sir. Thank you, everybody, for your patience so far. Okay, take a little bit of a breather. The next matter